video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation services for those on Zoom, you have the choice at the bottom of your screen of either floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. I have cue cards, so try to pay attention to me, even though sometimes on a large screen it's hard to see. But when you're narrowing in on your 30-second mark, I will raise the yellow card, and when you're out of time, I will raise the red card. So I ask that you be respectful of time and kind of wrap things up on your own so I don't have to interrupt you. For the first hour, to apply our study on extradition, we welcome, appearing as individuals, Don Bain, and we also have Timothy McSorley, a National Coordinator of the International Civil Liberties Monitoring Group. We welcome you both, and I believe you're in person in the committee room today, and thank you for accepting our invitation. Also, some administrative info quickly before we begin. I'd like to inform you of this letter sent by the clerk earlier today regarding mandatory headsets and microphones for witnesses appearing. That letter was sent to all committee chairs. I strongly invite you all to take a moment to read it. As per the operations related to organizing witnesses, appearances are vital. I would encourage you to keep in mind the letter's content when you send your witnesses list in order to facilitate them. I thank you for your usual collaboration. Without further delay, you have the floor for 5 minutes each, and as usual, followed by a round of questions from the members of the committee. So I'll begin by, yes. Yep.
Mr. Chairperson, if I may. I'll ask you the usual question, if I may. Have the sound test been conducted with the witnesses who are both online and not online, and were there positive outcomes?
Yes, they were. Both have been tested. So we trust that interpretation services will be able to commence accordingly. So over to our first witness for 5 minutes.
Thank you, Mr. Chair, and thank you to the members of the committee for inviting me to speak with you today on behalf of the International Civil Liberties Monitoring Group regarding the urgent need to reform Canada's extradition laws. The ICLMG is a Canadian coalition of 45 national civil society organizations with a mandate to defend civil liberties from the impact of anti-terrorism laws and policies, both in Canada and internationally. We have been deeply involved in the campaign for justice for Dr. Hassan Diab, whose devastating case you have heard about at length. This has led us to closely examine the need to reform Canada's extradition laws in order to prevent abuses of civil liberties and human rights committed in the name of countering terrorism. As you are aware, Dr. Diab was arrested by the RCMP in 2008 for extradition to France on accusations of carrying out a terrorist attack in Paris in 1980. While Dr. Diab was accused of committing a crime 30 years earlier, his arrest, hearings, and eventual extradition took place squarely in the political and social context of the so-called War on Terror that led to the severe rights violations in Canada. This same context applied to France. The same year as Dr. Diab's arrest, Human Rights Watch issued a damning report that found that, and I quote, French counter-terrorism laws and procedures undermine the right of those facing charges of terrorism to a fair trial. The report documented that it was common practice for those held on suspicion of terrorism to face psychological pressure during custody. This sadly reflects Dr. Diab's experience of prolonged solitary confinement, the length of which amounted to torture in violation of international human rights law. The report also raised concerns that judges in France had allowed the introduction of unsourced intelligence without sufficiently probing the validity of the information. This includes judges allowing for the inclusion of testimony obtained under torture in foreign countries in violation of the Convention Against Torture, to which France was and is a signatory. Once again, we saw the use of unsourced intelligence used in the case of Dr. Diab. All this was known before Dr. Diab's extradition to France, yet he was still extradited and faced the consequences of France's unfair anti-terrorism regime. An extradition process that appropriately considers human rights, civil liberties, and the right to a fair trial would have taken all these elements into account. Instead, given France's status as an ally and extradition partner, the detailed and serious problems of the country's anti-terror system were not appropriately considered. Others have spoken about extradition cases where human rights have been violated. You have also heard how Canada has an extradition agreement with India, despite reports of torture, and India not being a signatory to the Convention Against Torture. Importantly, India also justifies their grave human rights abuses as necessary in their self-defined fight against terrorism. Our own research has found that at least 10 countries that Canada has extradition treaties with have been singled out in just the past 3 years by the UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. They were singled out for introducing or adopting rights-violating counterterrorism laws. This includes France. Under Canada's current extradition system, we continue to run the risk of extraditing individuals to face unjust, rights-violating legal systems under murky and politicized accusations of terrorism. Indeed, there is the real risk that France could seek a second extradition of Dr. Diab and that our flawed system would grant it, despite all we now know and all that Dr. Diab has been through. Given all this, we join others in calling for reforms to Canada's extradition laws. We have publicly endorsed the recommendations of the Halifax Colloquium, as was shared with you earlier this week. And given the time restraints, I'd just like to share 5 very key points that we would like to highlight and emphasize in terms of reforms. First, the committal process must be modified to ensure it is not as heavily weighted in favor of the requesting state, including allowing the individual sought for extradition disclosure, including allowing the individual sought for extradition disclosure of relevant evidence, and to be able to bring their own evidence. Second, that Canada's domestic and international human rights and civil liberties obligations be explicitly taken into account. Third, that there be a rebalancing to increase the role for judges in weighing factors such as fairness, civil liberties, and human rights, among others, in the final decision for extradition. Fourth, that there must be increased transparency regarding extraditions in Canada, including annual reporting. And finally, fifth, that Canada's extradition arrangements with foreign countries should be reviewed on an ongoing basis. As a starting point, Canada should not have extradition treaties with countries that have records of human rights abuses or have failed to ratify human rights treaties. Thank you very much for your time, and I really look forward to your questions, and very happy today to be appearing with Mr. Don Bain, who I'm sure will speak a lot more about the intricacies of the extradition system in Canada. Thank you.
Thank you, Mr. McSorley. And now to Don Bain, please, for 5 minutes.
Thank you. So my perspective, members of the committee, is as a guy who's been 51 years in the criminal justice system in this country, and I can say that this is the most unfair process and law that I've encountered in that half century. I'm also Hassan Diab's lawyer. And on the first day of Dr. Diab's extradition hearing, counsel for the Department of Justice, the international assistance group that represented France, came up to me, introduced himself, and said, "Hello, I am so-and-so. I have never lost a case." I didn't say anything to that. There was nothing I could say to that. Good counsel lose cases. Sometimes the other side is better than you. Sometimes they have a better case than you. You don't always win if the system's fair. If you always win, something is seriously wrong in the process. So he said it all, proudly and unwittingly. I've submitted to the committee 2 documents. The first is a May 31st, 2018 letter sent to the Prime Minister, and the other is a memo on the French Court of Appeal decision. The first document sets out key serious flaws in the Canadian Act and extradition process. And the second reveals you could almost say comically, but it's tragic, the tragically unreasonable decision of the French Court of Appeal to order a trial of this man when their own professional investigative judges had already ruled there was no evidence to justify putting this man on trial. And indeed, the evidence of innocence was so compelling that he shouldn't be subjected, he and his family, to further prosecution. I'm happy to answer questions about these documents. Let me say that my views of the lack of balance and the critical shortcomings of this law and process aren't just my own. You may recall Justice Laforêt, the late Justice Laforêt of the Supreme Court of Canada, his daughter, when she wrote this, Anne Warner Laforêt, in 2002, as Dean of the Law School at UNB, said this about this act. Now, she was writing in 2002, so she had 10 years of experience with the act, and it's only got worse since then. She said these things. My view is that this new approach gives undue weight to the law of the requesting state as against the liberty of the person. And that's really the consistent message. This is out of balance, what's happened here. I'll continue with some of her other comments. The reality is that Canada has gone further than virtually any other country in facilitating extradition. We serve up our people. It has done so in the absence of strong empirical support for the view that such an incursion on the liberty of the individual was needed and in circumstances where Canada extradites its nationals. Canadians are subject to this. We don't protect our own citizens the way other countries do. She goes on to conclude as follows. The new act adopts a record of the case approach that allows for second and third-hand hearsay evidence with no assurance of reliability. And that happened in spades in the Diab case. And finally, I submit that the provisions applicable to admissibility and sufficiency in the new Extradition Act are contrary to fundamental justice unless the courts interpret the evidentiary provisions of the new Act so as to reestablish an appropriate balance, that word again, that allows the extradition judge to protect the liberty of the fugitive by assessing the weight and reliability of the evidence. Members of the committee, under this act, the judge is not allowed to assess weight at all. Justice Méranger, who heard the long extradition proceeding, said, this evidence is suspect. It makes no sense, but I'm duty-bound. It's so weak that I'm compelled to say there's no reasonable prospect of a conviction given a fair trial, but I'm compelled by the law to extradite. And that led to 3.5 years in France. That's all I've got to say.
Oh, perfect timing. Thank you, Mr. Bain. Now we'll go to our first round of questioning, and beginning with a round of 6 minutes each, beginning with Mr. Brock from the Conservatives.
Mr. Starts, may I ask a question of the chair? The witness, Mr. Bain, made reference to 2 documents that were submitted to the committee that did not find its way in my inbox. Is there an explanation for that?
I can look into it, and I'll find out. Mr. Clerk, have we received that? And would you be able to provide clarity on that?
Sure, Mr. Chair. The documents are still in translation, so they were a bit voluminous, so that's the reason why they're not available for now. But as soon as possible.
Hopefully that answers your question, Mr. Brock.
Thank you.
So we'll have them to you as soon as they're translated.
Thank you.
So, you're welcome.
Thank you so much, gentlemen, for your introductions and your willingness to participate in this important study. I have so many questions, but I have a limited amount of time, so I'll do my best. Now, the documentation, Mr. Bain, that you referenced, there was a purpose by which you wanted this committee to review it. One I recall you mentioning was a letter that you specifically drafted to the Prime Minister?
Yes.
Okay. What year was that?
The year was 2018, the day was May 31st.
Okay. And I note that in some of the briefing notes that my office provided to me, you're quoted in May of 2021 of saying or referencing that the Prime Minister publicly stated on June 20th, 2018, that we have to recognize, first of all, that what happened to him, referencing the Diab case, never should have happened, and make sure that it never happens again. That was June 20th, 2018. Your letter is May of 2018.
Yes.
Can you share with us details as to what you asked the Prime Minister to consider?
So I think the first 2 pages were dealing with the type of review that the government was going to mandate. But what will interest this committee is the following. And I write, "And what, sir, is so very wrong with the current Extradition Act?" And then there are numbered paragraphs. The first is, 1, the act unfairly deprives liberty, and goes on to explain how. 2, the unsworn allegation of a foreign official is presumed to be reliable evidence, and the Diab case showed the folly of such a presumption. For example, in Diab, the foreign official said, even though he knew it was untrue because he was in charge of the file, there was no fingerprint that the French had found on the bomber's hotel sign-in card. He wrote the record of the case in late 2008, early 2009. In 2007, the French had located an identifiable print on that card. They had excluded Hassan Diab as the source. So not only is it folly to, as Dean Laforet says in her extensive assessment of this act, to rely on second and third hand hearsay, we can't even trust a longtime ally to tell us the truth. This man's, that wasn't the only thing we weren't told. There were multiple other fingerprints that excluded this man. When the bomber was arrested, almost in a cartoon event, shoplifting pliers before the bombing, he was taken to the police station. The police didn't take a photograph of him. They took a statement from him. He filled out the statement and signed it. They found 16 fingerprints on that. 10 of them were identified as the police who handled the document. The 6 unidentified, none matches Hassan Diab.
Okay.
All of that did not appear in the record of the case because this invites this system where some foreign official who can't be cross-examined and doesn't have to swear that this is true simply certifies this is evidence we have. But he doesn't tell the truth, and he doesn't tell the whole truth.
Did the Prime Minister or his office respond to that letter?
In a kind of a generic way that, thank you, Mr. Bain, for your letter.
Have you ever had a chance to write a similar letter to the Justice Minister?
The Justice Minister, I believe, has this letter because I've met him.
Okay.
I had a face-to-face meeting with him and asked him, because of all of this, to undertake a review of the current law.
And when did you do that, sir?
This is 23, I would say. Dr. Diab came back to Canada in 2018. So I would say it was that year or the next year.
Okay. There has been some reference as well in my briefing notes from the Library of Parliament that the government may have made certain amendments or were prepared to look at certain reforms with the Extradition Act. To your knowledge, since you defended Mr. Diab, to your knowledge, have there been any changes to any parts of the current Extradition Act?
No.
again in my briefing note that makes reference that the Extradition Act was meant to modernize the system, simplify the system, reduce the delays, that it still had to be compliant with the Charter. Given your opening and given what I know about this case, the further can't be from the truth. So can you specifically outline the deficiencies in terms of the Charter violations that currently exist with respect to our Extradition Act?
So this letter does that. It talks about the folly of basing a system where liberty is involved of Canadians on unsworn material that is presumed to be reliable, that can't be tested, where there is no obligation of the requesting state to show exculpatory evidence, and let me add this, there's no full disclosure made here. They can pick and choose foreign states. We just trust them to be as honorable as Canadians would be. In the same
Section 7, Section 9, Section 11
you.
violations?
Absolutely, and even on the
Mr.
question...
Bain, I'm going to have to end it there. We're a little bit over time. Thank you, Mr. Brock. Over to you, Mr. Naqvi, for 6 minutes.
Chair, and good to see you again, Mr. Bain. Thank you for being present, and thank you for all the advocacy work that you do in the legal community. And Mr. McSorley, welcome. I'm very sympathetic to Diab matter. I've said in the committee before, I know Mr. Diab and the family quite well, but I'm also a little hesitant to relitigate that particular matter at this committee. Of course, the case is instructive to us from a policy perspective as to what lessons learned. So I just want to maybe perhaps move away from the actual precise aspects of that case to some of the policies that you may be advocating for us as we look at recommendations in this particular report. So to that, Mr. McSorley, towards the end of your presentation, I believe it was about 5 different points that you raised that we should be considered. Do you want to take some time to at least highlight 2 or 3 of those recommendations that you think are important?
Certainly.
Explain as to why they're important and why we should be considering them. Mm-hmm. Thank you.
I'll focus on the ones I think more closely relate to the mandate of ICLMG, and perhaps I'll leave to Mr. Bain some of the others. As I mentioned in my opening, that it's incredibly important that the system be modified so that international human rights and civil liberties obligations are explicitly taken into account. As I noted, the review of France's anti-terrorism laws clearly presented violations and concerns around the Convention Against Torture and Canada's commitment to fighting torture, and yet that was not adequately considered by the court at the time. There was a more recent case that we weren't involved in, but the Boilly decision, where essentially an individual was extradited to Mexico and faced torture and had raised those concerns, and that was also ignored when he was extradited, and in fact was just awarded $500,000 in a civil suit from the Canadian government because of the fact that his rights were violated. So we believe that that should be a key point of consideration. On Monday, Professor Harrington spoke at length about the need for increased transparency, and we agree with that as well. We believe that there needs to be greater transparency and reporting from the government on the number of extraditions, the types of extraditions and cases that those are, because there's a lack of clarity and a lack of understanding among the public. And even in our advocacy work, it's difficult to ascertain exactly how many extradition cases happen and on what grounds. There was a CBC article that, through access to information, demonstrated that I believe it was close to 99% of extraditions in Canada to the United States, at least, are agreed to, but that was only pieced together through their diligent research, but it's not something that's easily accessible. Finally, as been brought up, countries often give their assurances that they will move forward. For example, in the case of Dr. Diab, with cases on a timely basis, that they won't violate rights and that their systems are compatible with Canada's. But we find that Canada has dropped the ball in terms of ensuring, from our own perspective, that states are upholding civil liberties and human rights in their justice system. As I mentioned, there's been findings by the Special Rapporteur on countering terrorism and human rights at the UN that several of Canada's extradition partners have introduced and adopted anti-terrorism laws that violate fundamental rights. And so, a fundamental review needs to be done of Canada's extradition agreements, and it should be put in law, we think, that Canada will not enter into extradition treaties with countries that are found to be violating human rights, both domestically and international human rights law.
Thank you. Are these recommendations in line with the so-called Halifax proposal?
In general, yes. Yeah, we've worked closely with Professor Curry, and I believe those are all in line with the recommendations of the Halifax Colloquium too.
Mr. Bain, to you, I mean, do you have some specific suggestions in light of your experience, not only in Diab matter, but other extradition matters that would be a significant improvement to our extradition laws?
I do, Mr. Naqvi. I would say there are four that I would say to redress the imbalance. The first is the most important, and that's to do away with this unreasonable presumption of reliability, of third-hand hearsay, and instead put the onus on the requesting state rather than on the individual Canadian to prove the reliability of the evidence on which it relies, at least on a balance of probability, not beyond a reasonable doubt, just on a balance of probability. The system now has a reverse onus on the Canadian, the person saw it, and they have to prove it to what has become to be interpreted in the courts, an unattainable standard called manifest unreliability. Diab didn't even achieve that, even though the judge said this handwriting evidence, which the whole case ultimately hung on, was clearly unreliable. Every leading expert in the world said so. France has now said so in a separate analysis of their own report. Their own experts now say that report that got him extradited, we agree entirely. That's a quote with the defense experts who gave evidence. So they create a catch-22. That reverse onus and the presumption of reliability create a catch-22 for citizens in this country, for people in this country, that can't be met. It's simply a crazy situation. The other three are these. Full disclosure of when you're relying on expert evidence, full disclosure of that, full disclosure of exculpatory evidence, and full disclosure of all evidence sourced in Canada. That didn't happen in India. There's two more.
Thank you.
Thank you.
Hopefully we'll be able to get that out of you in the next questioning. Monsieur Fortin, for 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chairperson, and thank you, gentlemen. Now, Mr. Bain, I'd like you to complete your response if you would. I understand you don't have your headset on, so I'll just give you a moment to put it on. The witnesses weren't expecting questions in French, and yet Canada is a bilingual nation.
I've been here for... Peut-être quelqu'un peut...
Perhaps someone could assist the gentleman?
Alors, Monsieur Bain.
Mr. Bain, can you hear me? Testing 1, 2, 3. Testing 1, 2, 3. Can you hear the interpretation? Testing, testing 1, 2, 3. So you can indeed hear the interpretation, Mr. Bain?
Okay.
Excellent. So, Mr. Bain...
Now, Monsieur Fortin.
Merci.
Thank you, Mr. Chairperson, for your indulgence. I appreciate that. Now, Mr. Bain, I'd like to thank you and Mr. McSorley for being here with us today. I'd like you to complete your response in answer to my colleague's question regarding the recommendations. You said there were 4 particular recommendations with a view to amending the current legislation, and I'd be curious to hear the remainder of them. So please proceed.
Thank you, Mr. Fortin. The other two, and I don't say there are only four, but these are four that are, to me, critical if the system is going to work. Number three is if the requesting state, like France, does not in fact reciprocate with Canada so as to extradite its requested citizens to Canada, Canada should not extradite its nationals to such a requesting state. And I give the example of the French priest. You may recall this case recently, wanted for multiple sexual assaults against young people in Canada years ago. And France refused to participate in that process, saying, oh, that's too old. That case was no older than Diab. That's the third one. True reciprocity. Extradition is said to rely on comity, but there is no comity / reciprocity with France on extradition of nationals. And the last one, Mr. Fortin, is only extradition for a trial that is ready to proceed within a reasonable time, not for further investigation. We thought that was the law. We pointed that out to the Court of Appeal and Supreme Court of Canada, and they still let this happen. And of course, 3+ years in solitary resulted.
Merci, Monsieur Bain.
Thank you, Mr. Bain. I understood your first condition regarding the reverse onus and the balance of probabilities, then reciprocity, committee, and the reasonable amount of time. And then the final one escaped me. Could you repeat it, please?
I meant by the final one that there only be extradition for a trial that was ready to proceed within a reasonable time. And that's the fourth one, and not for any further investigation, that's what happened here.
The second one, Mr. Bain, was, if you would.
Full disclosure to the person sought of any expert evidence that the requesting state requires, any exculpatory evidence, evidence showing innocence should be disclosed, and certainly all evidence that is produced in Canada that doesn't come from abroad, whatever that evidence is, should be subject to the normal constitutional Stinchcombe rules of disclosure in Canada.
Merci. Est-ce que vous...
Thank you. Mr. Bain, did you discuss the matter with legal experts from other countries? In the case of France, for example, and Mr. Diab's case, did you discuss legal experts from other countries regarding whether or not those conditions were acceptable to them?
I did discuss with Jacqueline Hodgson, who is the leading British expert. She teaches at the University of Warwick. I went to England and up to Warwick to meet her in preparation of the Diab case. She was hired by the Tony Blair government when it was considering mimicking French anti-terrorism law and the use of intelligence as if it was evidence, which is going on in the Diab case. And so she has taught French law in France. She's fluently bilingual. And she made a study for the Blair government and the Home Office in the UK about the provisions that we, for example, have in our Act that permit reliance on this unsourced, unidentified intelligence evidence, and found that it would be in violation of, I can't remember if it's Article 5 or Article 6 of the European Convention of Human Rights. That's as far as I went, Mr. Fortin.
Est-ce que vous avez eu des...
Did you discuss the matter with the French authorities whatsoever?
No.
Monsieur McSorley, de votre...
Mr. McSorley, the same question of you. Did you have any discussions with foreign authorities or foreign legal experts who are working on extradition files regarding the conditions or the amendments that Mr. Bain is proposing? Unfortunately, no, we haven't had those kinds of discussions with any foreign legal experts. Well, it's my understanding that these conditions, at first blush, seem very logical, but are not necessarily acceptable in the eyes of foreign experts and authorities. Well, that may very well be the case. But what I would say is that there is a burden on Canada to protect our citizens and compatriots. And it's important that our law reflect and take that into account. Now, if the French legal system to combat terrorism doesn't suit our purposes and isn't in accordance with our perception of human rights and civil liberties, well, the onus is on us to ensure that protection. Question, do you know of any other states that...
We're time's up. We're actually a little over. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair, and I too thank the witnesses, not just for being here today, but for their advocacy for a long time on this issue. And it has, of course, taken our committee some time to get to this study as well. So I'm hoping, and I trust, you can see around the table, there's good engagement on this issue by all committee members, that we can get a good report completed soon. I'm going to start with Mr. McSorley. I think you, in your fifth key point, you talked about review of the treaties. And I presume you're saying they're not just review of the treaties, but the review of the human rights records and performance of our treaty partners. Is that correct?
Yes, that's correct. That there be a comprehensive review immediately of all treaty partners, and an ongoing review for changes in their laws. We look particularly at the issue of where some of those countries are at in terms of their counterterrorism laws, and found that they're lacking, and could provide maybe a starting point. But in general, that should be done. Yes.
And I think some have suggested we shouldn't have treaties with those who haven't signed the Convention Against Torture. But I think what you're saying to us is that's not sufficient. Merely signing the Convention Against Torture wouldn't qualify someone for having a treaty with us.
Exactly, yeah. So we would hope that a country that has signed the Convention Against Torture would respect their obligations. But as we know, there are multiple countries, including, there have been questions about whether Canada fully respects its obligations on that convention as well. So we think that there needs to be further review rather than just accepting it at face value.
And you mentioned that there were 10 countries, I presume, with whom we have treaties that UN bodies have cited as frequent violators of rights in this context. Can you say a little bit more about what the context of that idea of their frequent violators, and maybe what the 10 countries are, if you have that?
Certainly. So I have a list, but unfortunately the highlighting didn't print out, so I can't say exactly the 10. I might be able to identify some of them. You may be surprised that they include, off the top of my head, I know that, for example, France is included, Austria is included. I'm trying to identify some. I'll send the list to the committee because I do have it.
Thank you.
But what was identified, and I think it's important, is that in the current context there are multiple countries that have been cited by the UN for increasing counterterrorism laws that violate human rights in the pursuit of often pursuing their critics. We have seen in some countries that have more populist governments bringing in these kinds of laws in order to, as I said, silence critics and to target minorities. And so there's a rise that we've been seeing that is perhaps, I think, for a period after 9/11, there was a rise in these types of laws, and then perhaps a decrease. And in the last few years, we've seen a new increase of countries that wouldn't necessarily be on our list at first glance of countries that we would have to be worried about their counterterrorism laws, but are bringing new laws that engage in indefinite detention, that allow for the use of intelligence and unsourced information, and that engage in activities that would be considered tantamount to torture.
Thank you. Turning to you, Mr. Bain, you were very clear in highlighting four, I guess, key changes to the law. But I want to ask you something that we've heard a little bit more about, and that's the role of the International Assistance Group in the Department of Justice. And we certainly have heard some testimony questioning whether one part of a department can both be an advocate for the country who's making the request, and at the same time, another part of that same group is supposed to be defending the rights of those who are, have the extradition request against them. Can you speak to that question based on your experience?
I think it's not only an apparent conflict of interest, it's a real conflict of interest. And that's not all that the IAG does. When you come to the ministerial stage, the minister turns to the same people who were very ardent and aggressive advocates in the courtroom for advice on whether ministerially he should surrender. There's clearly a bias there too. So it's been recommended. It's not among my four because I didn't come with a vast shopping list, but the truth is it puts those people, however well-meaning, it would put any of us in an apparent conflict of interest and likely a real one.
And in terms of the other thing we've heard a lot about is the number of things that are assigned to the minister at the surrender phase, which might better be considered by the judge in the extradition hearing. Can you comment on the kind of things that we're actually leaving to the minister as a political decision, which are actually legal decisions?
Well, at the end of the day, virtually everything, because if you examine the role of the judge, and the judges have at least privately, if not publicly, lamented this, they are rubber stamps. They don't have a judicial function. They don't weigh the evidence. They don't make determinations of reliability. And so I know of very few ministerial decisions, perhaps one or two, where the minister declined to extradite, to surrender after a decision was made on extradition. But maybe you can be more, maybe I'm being too general in that answer.
No, that's exactly what I was getting at, is that judges aren't really allowed to judge
They
in the extradition cases.
Well, and interestingly enough, more than a decade ago, 2 decades ago, that's exactly what
I'm going to have to intercept you there, Mr. Bain. Hopefully, one of the other witnesses will give you a bit of time on that. I have to go to the next round of 5 minutes, and that's going to go to Mr. Caputo for 5 minutes.
Thank you. Go ahead, Mr. Bain. Finish up, please.
The Anne Warner Laforêt questioned why Canada even has judges involved in the process when so little is given to the judge to do. She was very prescient about how we were going off the rails with this act. And as I say, it's only got worse because the judges sit there. There's a culture, a judicial culture now, that has grown up that extradition is inevitable. We will go through the charade of a hearing, but in the end, it will always happen. And the judge, no matter, when we witnessed Justice Mélanger wringing his hands about the nature of this material they were putting in front of him, but he couldn't do anything about it. He said at one point, you know what I would do, Mr. Bain, if this was a trial in Canada. But the judges are so overawed by the concept of international relations and, I'm not supposed to tread on damaging relations with France or somebody else if I refuse this. So they really have no role. They don't make legal decisions.
Well, that's, I mean, I'm a bit of a nerd, so I'm going to ask you a question about this. Something I find interesting, I apologize if you've covered this, is the tension between what is a legal decision and what is a political decision, right? Because that's something that I don't think we often turn our minds to. And I'd like you to comment on something, whether this is the case. Because in some countries, as I understand it, you have the Attorney General, which is your legal officer, right? And then you have a Minister of Justice that's a political position, right? There's going to be some partisanship there. Does having those two titles reside in the same person, does that impact extradition at all?
That sounds like a dangerous invitation to go down a debate that was held in this country not long ago.
Well,
and I don't think I'm the person qualified to resolve that. I think you people are.
Well, I'm just asking for your opinion. I certainly don't know. What's that?
It's not what strikes me as being at the heart of what's
what
wrong
I'm getting
here.
At. Okay. This issue of disclosure I find interesting, troubling. How is it that Canadian investigative product is not disclosable? Can you walk us through that? That, to me, it doesn't feel right.
Okay, so I think the way to answer that is to read to you the provisions of the Extradition Act, Section 32.2, which provide you don't need to disclose the requesting state all the evidence. Exception, Canadian evidence. Evidence gathered in Canada must satisfy the rules of evidence under Canadian law, that would be including the Stinchcombe law of disclosure, in order to be admitted. The catch is that if the Department of Justice decides we're not going to put it in, we won't tell them about it, and we're not trying to admit it, so we don't have to disclose it. That's the problem.
So that's interesting in that the threshold for disclosure lies exclusively with the state, by that I mean the government, and the government lawyer. And if the government lawyer chooses to not rely on that information, it's not an issue of may be relevant, it's actually an issue of will be admitted or will be tendered. Do I have that right?
Right. What's the cost? The prosecutor makes a cost-effective analysis.
Now,
is it worth more to me if I disclose it and try to admit it, or is it actually going to harm my case? In which case you don't disclose it because you're not going to rely on it.
Now, I mean, this is interesting. I don't know if you used the term prosecutor there. Is that the term you used just a second
ago?
It is.
Is.
Yeah. I mean, because, some of us here have done prosecutions, myself included. A prosecutor is supposed to be an independent minister of justice who seeks truth rather than a conviction or rather than a certain outcome, right? So to me, there is certainly a tension between seeking the truth and choosing not to disclose something that may otherwise be exculpatory. You probably have no time but I leave you with that.
I agree with you. Valuable Crown attorneys do a wonderful service in our justice system. People who adopt that approach.
Thank you, Mr. Bain. Thank you, Mr. Caputo. We'll next go to a 5-minute round with, the next 5-minute round goes to Mr. Anand Sangari for 5 minutes.
Thank you, Mr. Chair. And let me thank both witnesses for the, sorry. Apologize for that. I want to first thank both of you for the enormous work that you've done. I do want to, I know there's a lot of discussion here on Dr. Diab's case, and you've outlined many of the concerns I think that that can be drawn from that. I'm wondering if you could both comment on the Meng Wanzhou case. I know there's a case of extradition as well in that regard, and I'm wondering if there's any lessons that can be drawn from there that may be relevant to the discussion that we're having today.
In the course of our work, we haven't analyzed the Meng Wanzhou case because it doesn't deal with counterterrorism issues, so I'll leave it to Dr. Bain to Mr. Bain, sorry, give you a promotion.
So Meng is an interesting case that you've raised because the argument is always made by the Department of Justice lawyers who work in this field, oh, we need to cut down these rights, or these won't be expeditious hearings. They are not expeditious hearings. They're not expeditious because there's so much argument all the time about what exactly is a judge allowed to assess here. And it goes on, look at Meng. How long did that go on? It went on forever because China could pay for enough, I say China because I know a little more about that case. They could pay for interminable arguments about reliability and so on. If we had a clear-cut system with a clear-cut onus on the requesting state to establish reliability on a balance of probabilities, judges know how to deal with that. They do it all the time. That's the judicial function. And a judge would control that kind of hearing, and it would move more expeditiously than the way they're unraveling now with lawyers desperate to find something to argue in the current system. They are not expeditious. That's a lesson from Meng.
Just going on to the issue of bilateral treaties or treaties with a number of countries that we have. I think it's over 51. I noticed that a number of countries, for example, Haiti is on the list. Haiti's going through some severe challenges right now. What is the test? And then just to follow up from Mr. Garrison's comments, what's the test for us to determine if a country is equipped to really have a fair trial in their country? Even if we have a treaty, what are the benchmarks that we need to keep in mind in order for us to proceed with an extradition?
Well, I think a key indicator could be looking at reviews such as what Human Rights Watch puts out, Freedom House, Amnesty International, and the international reports of human rights organizations. Canada and Global Affairs Canada regularly does assessments of the rights situation in various countries, and so I think that we could be looking at those and analyzing those to see, beyond the counterterrorism issues, just problems within the judicial system, whether or not people there are reports of whether or not individuals are facing fair trials, whether or not they're facing abuse or rights violations while in custody, because that's a big question. As we've heard, Dr. Diab spent 3 years and others have spent time in custody after being extradited where their rights are violated. It's not just in the judicial system. So I think that assuring that it meets the standard, and Canada has standards ostensibly in the Extradition Act that that the laws of the country that we're extraditing to must also meet the standard of our own laws, and so we should be looking at that more closely. You mentioned Haiti, and Haiti is one of 2 countries, along with India, who Canada has extradition agreements with, who has not signed and ratified the. Or has signed but has not ratified the Convention Against Torture. So looking at which human rights treaties they have signed on to, what their record is, would provide a tangible analysis of their system.
How about the systems that they have in place?
Mr. Unsengari, unfortunately, we're out of time. So going to the last round, we'll begin by Monsieur Fortin for 2.5 minutes.
President.
Thank you, Mr. Chairperson. Mr. McSorley, I was interested in the last question you were answering. I understand that there are about 10 countries that don't uphold human rights, and you singled out France, hold on a sec, Australia or Austria, that's right. Now, as far as the applicable criteria are concerned to determine whether a state will uphold or not fair process and due process, I didn't clearly understand your position. In your opinion, are there criteria that we should be able to rely on to assess the state of affairs in a foreign state? Response. Well, I didn't draft a list per se in advance, but when it comes to abuses I'll respond in English, it'll be easier.
Looking for violations while people are in custody, looking for issues around allegations and reports of torture while in custody, looking at issues around what kind of evidence can be introduced in court including unsourced evidence or evidence that's obtained under torture, and also looking at whether or not the laws that are being used are done in a way that respects the International Covenant on the Protection of Civil Liberties.
And I'm going quick because our time is running out, but France, why do you believe that France does not adhere to human rights in that respect? What criteria does France not meet?
It was around France's counterterrorism laws. So, for example, the ability to use unsourced information that could be derived from torture, and the fact that it's been demonstrating that French counterterrorism judges allow that to be introduced into evidence and don't appropriately probe the validity of that information. We believe what we know is a violation of the Convention Against Torture and demonstrates, one of the criteria that we think should exclude extraditions on the basis of counterterrorism prosecutions.
Et est-ce qu'on devrait appliquer les mêmes...
And should we apply the same rules and procedures to extradite a Canadian citizen as a foreign citizen, foreign national?
First and foremost, the protection is for Canadian citizens, but at the same time, Canada has a duty under, for example, the Convention Against Torture not to deport or extradite a single person to torture or to situations where they would be faced with evidence obtained under torture. So I believe that it should still apply to non-citizens as well.
Thank you, Monsieur Fortin. Last, we'll go to Mr. Garrison for 2.5 minutes.
Thank you, Mr. Chair. I want to go back to Mr. Bain, who, when you told us the first of your points, which you said was the most important, and that's doing away with the presumption of reliability of the record of the case.
Combined with the reverse onus on the individual to demonstrate what's called manifest unreliability, and that together that produces an inherently inevitable extradition.
And do we find those two things actually in the extradition law, or is that more in the case law that's developed?
No, it's in the Act.
It's in the Act.
It's right in the Act.
So
the first part of it, the creation of a statutory presumption of reliability of unsworn hearsay evidence is in the Act. In 2006, on a constitutional challenge to the regime in a case called Ferras, Ferras, the Supreme Court tried to save the system, saying we have to equip judges to be able to assess reliability. The problem is, since 2006, Ferras has proved to be a false promise because this mountain of a wall that is demonstrable, manifest unreliability has never been achieved. You can't do it. If Diab did not, with all the experts in the world, let me explain. The first two handwriting samples used, alleged by France against Dr. Diab, it turned out the two supposed experts in France relied on the wrong person's known handwriting. They were not comparing Dr. Diab's handwriting. They were comparing his wife's handwriting, and they identified her as the 40 to 45-year-old male bomber who signed in at the hotel. When that came out through expert evidence by the international experts who recognized they aren't even comparing Dr. Diab's handwriting. This is another person's handwriting. They got another person. That person did not follow accepted methodology. The Swiss experts said it's totally unreliable. The leading Americans said it was unreliable. The leading UK authority said it was unreliable. And the leading Canadian said it was unreliable. So that has grown up in the case law, but it should be clear that if you don't have this presumption, then you haven't put a reverse onus on the person.
Thank you.
Thank you. Thank you, Mr. Garrison, and thank you, Mr. Bain and Mr. McSorley, for your very informative and very insightful testimony today. That concludes the first panel. We'll just suspend for a quick 5 minutes while we have the next panel set up, and anyone needs to do a health break, they can do that. So I will suspend for just 5 minutes. So we'll see you back at 5:40. Back, everyone. We now go to our second hour of meeting on the study of extradition law reform. With us now to complete their appearance of February 1st from the Department of Justice, it's Janet Henchy, Director General and Senior General Counsel, International Assistance Group, National Litigation Sector, and Aaron McKee, Director and General Counsel, Criminal Law Policy Section. So thank you for being with us again, and welcome to the committee. So if the officials have anything to add, please do so. If not, we adjourned at Monsieur Fortin's round, so we can commence from there. But I'll leave that to you if you want to comment as to if you want to add anything before resuming a round of questions. I'll leave that to you, Ms. Henchy or Ms. McKee.
It's hard to ask a lawyer if they want to add something and have them say no. So I will just make a few comments because I've had the opportunity of reviewing some of the testimony from previous days and a little bit from this afternoon. So I think we never got a chance to talk about this the last time, which is the really important principle of extradition, which doesn't seem to be accepted by most of the witnesses that you've heard, which is extradition is not a trial. And the reason it's not a trial is because the whole premise of extradition is that a person is going to have a trial wherever they're being extradited to. So to turn an extradition hearing into a trial, first of all, delays the opportunity for that person to face justice in the jurisdiction where they're headed to. It delays access to the witnesses and the process in the foreign jurisdiction, which, as you know, under the Canadian system is something we try to avoid. We try to get people to trial as quickly as possible. So most of the recommendations that have been put forward by many of the witnesses seem to have ignored that point. That is, that these people that are being sought for extradition will have a trial. It's built into the system that's what's intended, and by calling witnesses and cross-examining witnesses and turning the extradition process into a trial, we are actually delaying the person accessing justice in the country that's seeking their extradition. So I could go on, but I'll stop there and let you ask questions.
Okay, thank you. We'll begin our round with Monsieur Fortin, who I don't believe any of his minutes were able to be optimally used. So we'll begin with 6 minutes from Monsieur Fortin.
Merci, Président.
Thank you, Mr. Chairperson. Thank you, Ms. Henchy and Ms. McKee, and sorry about the trouble at your last appearance. Now, listen, just before you, there were two witnesses, Mr. Bain and Mr. McSorley. Mr. McBain put forward 4 proposals that may improve the Extradition Act, and I'll go through them quickly. First, require from the requesting state the reverse onus, the burden of proof, not beyond all reasonable doubt, but in line with the balance of probabilities. That was the first. Second, complete disclosure of the evidence, even parts of the evidence that may be exculpatory, like in a criminal trial in Canada. Third, require that the requesting state have a reciprocity agreement or committee agreement with Canada for extradition. 4, ensure that the process can be held in a reasonable time frame, i.e. avoid what occurred with the Diab case, pre-trial detention over a number of years because the requesting state that called for the extradition wasn't able to proceed quickly. Now, I'd like your thoughts and input on those 4 conditions. Ms. McKay and then Ms. Henchy, your thoughts.
I'll go through the first 2 and then I'm going to ask you to clarify the third one because I didn't fully understand what that third point was. So the burden of proof is always on the requesting state or Canada in the sense that we have to establish that there is a prima facie case that would constitute an offence in Canada if that evidence took place in Canada, if that conduct took place in Canada. So all this comment about the burden of proof being...
Isn't that done on file? Sorry to cut you off, but it was my understanding that you took it for granted that was what on file was complete and compliant. I didn't realise that there was a pre-trial evaluation. Perhaps I'm mistaken.
Kind of conflating the 2 things that previous witnesses, I think, may have done, which is, yes, there is no requirement to determine whether the evidence is admissible in the sense that it's put into a record of the case, it's a summary of the evidence that the requesting state is relying on, but the sufficiency of that evidence. So once the court receives that evidence and looks at it, it's for the court to determine its sufficiency. It's not determined in advance. The person sought doesn't have to prove that it's not sufficient. The requesting state has to argue the sufficiency of the evidence they're relying upon. So you've heard some comment about how all the evidence hasn't gone forward, and I think that's sort of part of one of your questions. It's to the detriment of the requesting state if they don't put enough evidence forward. So they provide us with a document that outlines the evidence they're relying on, and it's similar to preliminary inquiry in Canada. So the concept is we're not having a real trial, we're just establishing that there's some evidence that would justify having a trial, which is the same test as we have in preliminary inquiries in Canada. So you don't waste the court's time with a trial if there's no evidence to justify going forward. So it's the same test, and it's a similar process where in a criminal domestic preliminary inquiry, the Crown decides what they're relying on. They don't necessarily put the whole case in front of the court. But with respect to extradition, just to clarify, it's the requesting state that's deciding what's going in front of the court, not what's been referred to as the prosecutor or the lawyer for the Attorney General of Canada who's appearing in front of the court. They're putting forward the case provided to them by the requesting state. So it's not a question of deciding, well, how much of this will we put forward? It's there. We put it forward. That's what they've asked us to rely on. And if it's not enough, that's to their detriment. So that sort of answers the first question, I think. I don't think that it makes sense to build up the level of proof to a higher level. It's a level that we're familiar with in the criminal justice system, the prima facie case that's used in a preliminary inquiry. It wouldn't make sense to make it beyond a reasonable doubt because that's the trial standard. Yeah. So the standard that's being proposed is what you use at a civil.
On parlait de balance de
Well, we referred to balance of probability and not beyond all reasonable doubt. We agree on that.
In the criminal context, this is a very known standard. It's the standard that we use in preliminary inquiries. It's not, balance of probability is not a standard that's used in the criminal context. So it would actually be not something that the criminal courts would be familiar with in the context of a criminal proceeding. And so as far as the disclosure of the proof goes, we disclose what we're provided by the requesting state, but they don't have to give us everything they've got. But if we were in possession of something that was actually exculpatory, we would disclose it. So the statement that's been made repeatedly that we hang on to exculpatory evidence, we don't have the whole case because it's in the foreign state. But if we have something, we're disclosing it. If it's exculpatory, we'd certainly be disclosing it.
Est-ce qu'on pourrait pas le demander?
Could you ask for it proactively?
Can you ask for disclosure? Well, we don't have
Est-ce qu'on pourrait pas demander?
Couldn't you ask for full disclosure from the foreign state?
And the reason for that is because it's not a trial. So the idea is that we're just doing this as though it was a preliminary inquiry. Is there enough evidence to justify having a trial? And then the evidence will be provided according to the laws of the requesting state if the person is extradited.
Et sur le
Third criteria, the requirement of a reciprocity agreement between Canada and the foreign state. What do you think? Is that a good idea?
Sorry, we're out of time, but
yes, very briefly.
Reciprocity. There always is. That's the principle of extradition.
Alors, je reviendrai.
Well, I'll come back to that in my next turn regarding the fourth criteria, Mr. Chair.
Thank you, Monsieur Fortin. We'll now go to Mr. Garrison for 6 minutes.
Very much, and thank you for the witnesses. I know it's an inconvenience to be dismissed for technical reasons and have to come back, so we do thank you for that. I want to ask about the reporting function. So what we hear and what we've heard through testimony is that there really isn't reporting on the extradition process. So has that been a conscious decision not to publicly report on the extradition process, or is it simply the practice?
So I think it's a combination of things that go into that. So I'm not really even sure what's meant by reporting on the process because it's a public process, right? So it's reported on in the sense that it's in the courts. So when an extradition case goes forward, it's public and it takes place in a courthouse, and all the materials are open to the public. So that makes it public. We do have statistics, which are some of our statistics are placed on our website. So that there is no issue with that. We do put forward statistics, and we're asked on a regular basis by the media for statistics, which we provide. So statistics aren't really an issue, but when it comes to whether we have an actual reason for, again, I'm not sure what we mean by reporting, but when we get requests for extradition, at that point, they're confidential unless we move forward with them. So there are quite a few requests we receive for extradition that never see the light of day because we don't authorize them. So the problem with necessarily disclosing all of that is that we're identifying what is a case that's at an investigative stage potentially in the sense that it's still ongoing in the foreign state. So if we say we've received your request and refused it, we're identifying that for a person who's potentially still subject to a prosecution at some point in the future. So there's that kind of process where you don't identify, for example, that you're necessarily investigating someone even in Canada before you would proceed to trial. But once a person's charged, then it becomes public knowledge. So
So you're saying it would be easy for us to go to the website and discover how many extradition cases there were from which countries and the rate of people being extradited?
No, it depends on the country.
It doesn't seem to be possible to do that.
Depends on the country. So you would be able to find that, for example, from the United States. And the reason why we don't disclose it for every country is because of that whole issue of identifying the existence of a request. So a lot of countries we don't deal with very often. So we might have one request in 5 years from a particular country, and if we identify that, we could be potentially identifying the request if we didn't execute it. So honestly, we could do a better job at disclosing some of our statistics, but there are some that we just simply couldn't because it would reveal confidential information. But the reason we disclose it with the United States is the quantity of requests is so large that we're not going to identify a particular request by providing the statistics.
And so it's safe to say that the bulk of the requests for extradition and the bulk of the proceedings involve the United States.
That's right, yes.
And I guess I have a question about that, since we say that we have an agreement with the United States, but we have wildly different criminal justice provisions state by state in the U.S. How do we deal with that question?
Well, yeah, that is a good point. So the requests are coming to us centrally, so they all come through the Federal Department of Justice, and they have to regulate that they're consistent with the requirements of the treaty with Canada. So, and in any particular case, there might be an issue that would arise because it's from one jurisdiction versus another, and those would be addressed on a case-by-case basis. So, for example, some jurisdictions have the death penalty, some don't. So if there's a death penalty, we'd be seeking a death penalty assurance from that particular jurisdiction. There's other issues that come up that are specific to particular jurisdictions, and we go back and seek information in relation to the circumstances in that particular case so that we're able to address whether or not it would be fair in the circumstances to extradite. And I should just say, in response to something I heard earlier on, there are cases the minister doesn't surrender. But we don't advertise it as much because the decisions of the minister are sent to the person sought and they're personal. And when the person is discharged, they don't advertise the fact that they were discharged. Whereas when they go to court and it's overturned by the courts, then of course it's public and everybody can see it. But I can tell you, for example, in the last 5 years or so, this year so far, so we go by fiscal year, so 2021 to 2022, the minister discharged on 3 occasions, the year before 2 occasions, the year before 4, before that 5. So he does discharge, but then quite apart from that, there are quite a number of cases where we receive requests, but we do not issue an ATP. So again, last year we refused to issue an ATP on 18 requests that we had received. So there's usually about 25% of the requests that we receive we do not authorize. Most of those are not with the United States because the United States has a system that's considerably similar to ours. So in most instances we would go forward, but not always, depending on the evidence that they've provided.
In the case of when assurances are asked for, is there a systematic monitoring of the performance on assurances by the IAG, or do you have the resources to do that?
So we don't actually have the role to do that. So monitoring of assurances would be something that would be handled by the Global Affairs, because once the person is outside of the country, we don't have any control over what goes on with them, but Global Affairs is responsible for dealing with...
And so they report back to the Minister of Justice then?
Well,
I have trouble seeing how that works then, because the Minister of Justice is the one who's made decisions and asked for assurances. Where's the reporting on that performance then?
Yeah. So if there was an issue, they would be responsible for following up with the foreign state to say you're not abiding by the condition in these instances.
So it's no longer the responsibility of the Minister of Justice once someone's extradited.
Only insofar as there's nothing the minister could do when the person's already in another country, right? We don't have the minister that has control over things or has influence over things that happen in other countries would be the Minister of Foreign Affairs. So that's why.
So we don't ever do assurances that are conditional.
Assurances are conditional.
Well, if you're saying that a trial would proceed within a reasonable time period and it doesn't, we simply say, well, that's too bad. We didn't get what we asked for.
So we wouldn't ask
Thank you,
for something
Mr.
like that?
Thank you, Mr. Garrison. We're out of time. Next, I'm going to go to Mr. Brock for the next round of questions for 5 minutes. Mr. Brock.
Actually, Mr. Chair, it would be Mr. Van Popta.
Okay, Mr. Van Popta.
Thank you, Chair. Thank you, witnesses, for being here. Ms. Henchy, I'm going to ask you about a British Columbia case, the case of Jassi Sidhu, who was murdered in India in a so-called honor killing. And the people alleged to have committed the murder were her very own mother and her maternal uncle. And those two people made it back to Canada, and they were successfully extradited back to India. But it took 17 years. And in that case, the two accused people argued in the Canadian court that they would be likely mistreated in an Indian prison. And you were quoted in the CBC News, and I'll give the benefit of the doubt that they quoted you correctly. It undermines the entire concept of extradition and sending people to the country where they have allegedly committed the crime if we refuse to surrender based on imperfections in our treaty partners, even sometimes large imperfections. Would you mind to, first of all, you remember saying that, and would you mind to expand on that?
I argued that case in the Supreme Court. I don't remember everything I said, but as you all assume that I'm properly quoted. So what I was trying to express is that again, a principle of extradition is that we accept that every country is not going to be the same as us, and we're not going to conduct a trial the same way in a foreign country as we conduct the trial here in Canada. And although we expect certain fundamental safeguards, we cannot expect exactly the same system, and our system is also not perfect. And so when we're seeking extradition from other countries, they also criticize us, and that's part of kind of the back and forth that you have with respect to the extradition system. But what is important is that we're ensuring that the imperfections are not contrary to fundamental justice. So we're looking at ensuring that a person is going to have a fair trial and that a person is going to be treated properly while in prison. And in fact, in the Bideshan Sidhu case, the case where Jassi Sidhu was murdered, we extradited subject to a number of assurances that they would be treated properly while in India, including that we could have access to their trial, and those would be people from the Ministry of Foreign Affairs that would have sat in on their trials, that they would have access to consular services, that they would be treated properly while in prison and be granted proper medical care. So these are the kinds of assurances that sometimes are necessary when a country is significantly different from ours in the way that it conducts its judicial system and its correctional system. But just basic little differences or issues, there's no such thing as a perfect system, and I think that's what I was trying to say.
Fair enough. Thank you very much for that. So you heard Mr. Bain give evidence in the earlier panel, and he made reference to the Rivoire case, which is a case where we sought extradition from France for a person who is accused here in Canada of sexual assault many years ago, and France turned down that extradition request based on the facts being so old. Now, we don't have a statute of limitations on sexual assault cases. And Mr. Bain said, well, there's a lack of reciprocity with France, that being the evidence of that, and that should undermine or should certainly inform any treaty that we have with France. So do you have a comment on that?
Yeah, I think actually one of the reasons why France didn't extradite in the Rivoire case was because Mr. Rivoire being a French national. I know that's one of the topics that's come up quite a bit about whether some countries extradite their nationals and Canada does and others don't. And that really is a difference that exists in the extradition world. Our like partners all extradite their nationals, United States, Australia, the United Kingdom. It's a characteristic of common law countries and the reason for it is that we don't have jurisdiction to prosecute for offenses that occur extraterritorially for the most part. There's some exceptions to that. So in order to ensure that there's not impunity, we extradite our nationals so that they will face prosecution when charged with serious offenses. in countries like France, in particular France, as part of their constitution, they do not extradite their nationals. That's a policy difference that we probably disagree with, because we think that you should be prosecuted in the location where the offense took place. But that's a legitimate policy choice that was made by France and a few other civil law countries. And the end result of that is you either extradite or prosecute. That's kind of the policy. So if you're not going to extradite, then you have to consider prosecution in your jurisdiction.
Out of time.
I got the big red sign, yeah.
Thank you, Mr. Van Popta. Next, I'll go to Mr. Nakvi for 5 minutes.
Thank you very much. I think you were present when Mr. McSorley and Mr. Baines were making their deputation, and there were 5 recommendations that they presented by memory. Are you able to comment, or at least some of the key elements that, and actually Mr. McSorley made 5, and I think Mr. Bain had about 4 different recommendations, but some of the key pieces that are you able to comment on, so that we get Department of Justice perspective on those recommendations?
I wasn't actually here for except for the last 5 minutes of their testimony, so I don't know what the 5 were, but I know that your colleague mentioned some things. So he mentioned the requesting state should have a burden of proof of balance of probabilities, so I already addressed that.
Yeah. Reciprocity was the other one.
There's the disclosure, I addressed that. The reciprocity is kind of where we stopped, but I think that's what I was talking about with the last question, which is reciprocity does not necessarily mean identical. So it means that when we make a request to France, so they make a request to us in this context of the national extradition of nationals, you have to either extradite or prosecute. So the idea behind it is that we will ensure that justice is done and the person is not getting safe haven from prosecution by not being extradited. So the treaty actually specifies that we are not obliged to extradite nationals, but our law provides that we do extradite nationals because we don't want them to go without being prosecuted, because we don't have jurisdiction to prosecute for a lot of basic criminal offenses like murder and sexual assault, etc. So that's all I've got. What were the other 2?
There was another one. I'm going by memory as well, so pardon me. There was one around timing of extradition, which was around when it's imminent or that a trial will be starting in the requesting country.
That's right.
So I think that relates to
yeah.
Mr. Diab's case, for example, where I think he was in prison for 3 years before the trial came about in France.
Right. So I have to be very careful about talking about specific cases that are, and that one is still ongoing in a number of different ways. But when somebody is extradited, there has to be evidence that they've been charged with an offense. And there was argument before the courts, I think I can mention it because it was before the courts in the Diab case, that didn't constitute being charged because he was under what they call a form of investigation, but it was found to be the equivalent of being at the preliminary inquiry stage in Canada. So it's such a different system that they have in France, and that's again where we have to be very careful not to try to superimpose our particular approach on the foreign country. So the courts in Canada and also courts in the UK have found that particular approach in France, where they bring the person in front of an investigating magistrate, is kind of a long version of a preliminary inquiry, and it is the equivalent of being charged. So we do have a requirement that a person has to be charged. It's just a question of what does that mean in a particular country.
So let me ask you this question, and this I'm mindful of asking you this question of the fact that it may be an unfair question. So
I don't like unfair questions.
So pardon me, but we also have an advantage of sitting in front of 2 experts on extradition law. You obviously know this piece of legislation and the application of it quite well. In your view, is there room for improvement in the current legislation? If so, if you had a wish list of things that you think needs to be modernized or amended, the unfair part is that's the unfair part. I think this may be a good opportunity to share with a group of legislators who are looking at how the bill could be serve Canadians better.
Well, I'm happy that you knew in advance it was an unfair question because I can't really answer most of that other than to say there's no such thing as a perfect piece of legislation, just like there's no such thing as a perfect system in any country. So obviously there's ways that it could be improved. And we would never say otherwise. That does not necessarily mean that we would endorse all of the ways that people are proposing, because it's important that changes to legislation are not just made because of one particular case where somebody didn't like the outcome, but you have to look at the entire system and the principles behind it. So I would just ask that when we look at some of the proposals that have come forward from some of the other witnesses, remember that they are from a particular perspective, and we also have to look at the perspective of the administration of justice generally. We have to look at the perspective of our international partners. We have to look at just the general system of extradition as a whole and the principles behind it, and the fact that we are really, without extradition, we are creating a system of impunity where criminals can just hide wherever they want to avoid being prosecuted.
Thank you.
Forgot to look for the sign.
Mr. Naqvi, next we'll go to for a 2.5-minute round, beginning with Monsieur Fortin.
Merci,
2.5
Monsieur.
minutes.
Thank you, Mr. Chairperson. Ms. Menchie, I'll continue with you. The fourth condition, you raised it briefly with my colleague, Mr. Naqvi. It was what Mr. Bain was referring to, i.e. to ensure that a process was taken in a reasonable time frame in order to avoid situations like what occurred with Mr. Diab. For 3 years he was detained in a foreign prison without a trial and due process. Now, to me, that seems entirely reasonable, but perhaps I'm missing something. Do you believe that we need to amend our Extradition Act to require that Canada the trial will be held within a 6-month time frame, or provide some sort of evidence that they are prepared to proceed? Would that be appropriate?
Question before that about reciprocity. So remember that whatever...
J'ai seulement 2 minutes.
I only have 2 minutes. I probably only have 90 seconds left. If you could talk about the time frame, please.
If we seek to insist upon a 6-month delay in another country, then that reciprocity will require the same delay for us, which we would not even be able to abide by. So what you need to look at the criminal justice system generally in Canada. There's all sorts of things that happen that cause things to be delayed that are outside of the control of
Non, mais si on n'est pas capable...
Well, if you can't hold a trial in a reasonable time frame for a foreign national, well, you know, why not leave that individual in Canada and transfer him at a later stage? That strikes me as reasonable, but perhaps I'm missing something. Don't you think that would be a reasonable approach?
Is reasonable. So I agree with that point. So it is not unheard of that someone would argue, you can't send me to this country because I'm not going to get tried within a reasonable time, and we would go back to the country and say, do you have laws about ensuring that somebody's tried within a reasonable time? For example, the United States has speedy trial laws, and we refer to that pretty regularly when people raise concerns about that. But to say, I think it would be unduly restrictive to insist upon a particular time period, because there are so many things that you cannot predict about how a trial is going to unfold.
Excusez rapidement.
Sorry, I probably have run out of time, but do you think that Mr. Diaz's case was a reasonable one?
On to that.
Merci.
Thank you.
Thank you. Next, we'll go for a 2.5-minute round to Mr. Garrison.
Thank you, Mr. Chair. And of course, I'd like about 2 more hours. But so I'm going to have to choose of the questions I would like to ask. But I do want to say that, Ms. Henchy, your opening statement that other witnesses were suggesting that there should be a trial, I don't think that fairly characterizes their suggestions. I want to ask about the surrender process. And in the law, there are certain things the minister is required to consider, and there are other things which are left to the minister's discretion. And one of the concerns that I have is that the list of required considerations doesn't match the Canadian Human Rights Code. In other words, in the Canadian Human Rights Code, we have things that, like gender identity and gender expression, that you might expect to be included in things the minister must consider before a surrender decision. Can you tell me how that operates at this time, since that list is different?
Yes, I can. So as you can imagine, that's the case with a lot of Canadian laws. At a particular point in time, you list, there's an enumerated list of grounds of discrimination, and as time progresses, that changes and expands. And there's a great many different laws and agreements that don't list everything that we would consider to be a ground of discrimination in today's day and age. But that's covered by the fact that extradition has to be in compliance with the Canadian Charter of Rights and Freedoms. So even though it's not listed in the Extradition Act, the minister is bound by the Canadian Charter. And one of the provisions that is mandatory is that the surrender cannot be unjust or oppressive. And unjust or oppressive has been found to be the equivalent of contrary to Section 7 of the Charter, so contrary to fundamental justice. So those extra provisions that are not specifically listed in the Extradition Act would be covered by the Charter.
And if someone felt that hadn't been considered and should have been, and I'm going to stick to gender identity because I think that's one where people are at great risk outside Canada, is that reviewable for that omission?
Yes. So a person generally raises the concerns that they have. So, for example, there's a case that took place in Mexico some years ago where the individual was gay, and he was concerned about how he would be treated in prison in Mexico, and we ultimately ended up getting an assurance from Mexico about his treatment, and he was not mistreated once surrendered. But so that's the person raises the concern, the minister takes it into account. The minister has to issue written reasons, and if his written reasons don't sufficiently address that, it can be judicially reviewed, and often the minister's decision is judicially reviewed, and the court would address that. And if the court was unsatisfied with the minister's failure to address a fundamental right under the Charter, then it would be returned back to the minister for him to reconsider that and explain explain the circumstances.
Thank you. When the chair's virtual, it's tempting just not to look at the screen and to continue.
I'm sorry, I didn't notice.
No,
Thank you, Mr.
It's tempting for me not to look. Thank you.
I will now go to the last 5-minute round, and we'll begin by, I believe it is.
It's Mr. Caputo speaking here.
Mr. Caputo, sure.
Thank you. Thank you, Chair. I just really want to put this issue to bed here. The two witnesses, do you have an obligation to disclose exculpatory evidence either in your possession, any exculpatory evidence, do you have an obligation to disclose that?
I would say yes. But the reality is we're not. It's a weird question because this isn't a trial and we don't possess all the evidence. So we get what we receive from the foreign state and we disclose it.
Okay, so what I'm getting at is, if you have exculpatory evidence in your possession or within your control, do you have a duty to disclose that?
I would say we have an ethical duty to disclose it. So yes.
Okay, that's what I was 100% getting at, and that would be in accord with my understanding. Now You've heard a lot here. It sounds like you've listened to testimony and all that. And, obviously you bring a fresh set of eyes to this. Is there anything that you've heard thus far where you think, you know what, this is something I'd really like to clarify? The floor is yours at this point.
I wasn't ready for that question.
Well, I just want to, because frankly, you know this area better than I do. So I would prefer to hear from you if there's anything you want to clarify, because you're the one who knows this area. So I can ask you a specific question if you like, but this to me is important to hear your perspective.
Well, one thing that I just wanted to mention is that this is an area that extradition is an area that's very heavily litigated. So the thought that somehow people's rights are being ignored ignores the fact that it's very heavily litigated, and it's also gone to the Supreme Court of Canada for a subject matter more often than a lot of other areas of the law. So we've got a lot of guidance from the Supreme Court of Canada. And to suggest that the Minister of Justice is running wild, doing whatever he wants to do, and he can get away with it because he's got this massive discretion. The discretion is to operate within the realm of the law. So if he's stepping outside of what the law requires, then he's going to be overturned by the courts. And on many occasions, we have been given guidance by the Supreme Court on how to deal with particular aspects of extradition. So although the law sets out the terms, we've had the standard of review determined by the Supreme Court. We've had how to deal with defenses in foreign countries determined by the Supreme Court. The Supreme Court explained how we are to address determining double criminality, what the rules are with respect to surrendering a Canadian citizen in the event that they're sought for extradition, what do we do with refugees. Not at the Supreme Court, but the Ontario Court of Appeal provided us with guidance on how to deal with Indigenous persons who are sought for extradition. So this is not some wild free-for-all. There's judicial oversight, and there's considerable judicial oversight, and we've been given a lot of guidance by the Supreme Court that has helped to put in place this this system in a way that protects the rights of others. But I also want to mention, because it seems to have been suggested that we have a system in Canada that provides for no rights for anybody compared to other systems. Canada has one of the, if not the, most rigorous extradition systems in the world. And we're familiar with this because we deal with all these other countries. So a lot of countries have a very pro forma approach to extradition. You just say, we want this person for this particular offense, they've been charged. We have a treaty, and off you go. Between European countries, there's a no evidence rule, so they just extradite in and amongst each other without any requirement for any evidence to support extradition. I'm not sitting here telling you we should do it that way. I'm just telling you that it would be wrong to suggest that the Canadian extradition system is some kind of wild west of extradition, and around the world everyone else has greater rights. We have one of the most robust extradition systems in the world.
Thank you. That's very helpful. When we talk about different ways of doing things, in law, one of the biggest issues you have is the clock, as in things take time. And you just mentioned you've got a decision, you have a review, you have an appeal of the minister's decision, potentially appeals of that appeal. How long does the average extradition take? And is that something we have to consider? I mean, especially when we consider deterioration of evidence, people dying, is that an issue?
Yeah, it is an issue. And that's one of the reasons why we want extradition to move on an expeditious basis. And if we were to change the law to require witnesses to be heard and cross-examined, we would never finish our extradition hearings in any kind of reasonable time frame. So an average extradition where the person goes through all of those stages, 18 months to 2 years. Very litigious case, it can go on for 10 years. That's not the average, but it's happened.
So an average case will typically be 18 months to 2 years, but it can go on for 10 years. And I imagine that also depends on funding, things like that.
That's right, yeah. The big red sign is up, yeah.
Thank you, Mr. Caputo. We'll go for our final round of questions with Ms. Diab for 5 minutes.
Thank you very much, Mr. Chair, and thanks for the witnesses. I think this has been our second or third day that we're hearing these, so we appreciate you coming, and I know you have a wealth of knowledge here. Can you tell me, we've talked a lot about this, but the intersection of Department of Justice and Department of Foreign Affairs in the case of extradition, can you tell me how they work together, particularly when an individual has been extradited outside of Canada?
So I'm not sure if you're asking how do we deal with the request from the beginning to end. Where does Foreign Affairs come in and where does Justice come in? So yeah, so
you can, and I'm particularly, I guess I'm concerned where there's human rights violations or there's things happening when the individual hasn't left yet, and do we investigate countries they're going to in terms of should we obtain conditions or what they're going to do when they're there, and as well when they actually arrive to the other countries, what happens there?
So when we first receive a request, if it's not from a country that we're very comfortable with and used to dealing with, the first question that we are asking ourselves, is this a country that we could send somebody safely to? And that will involve consulting with our partners at Foreign Affairs to ask them, what information do you have about the country conditions in this particular country? And if it's not obvious that there's a problem, that may lead us to move on to the next stage. But our first step is to consult with Foreign Affairs when we're dealing with a country that we're not 100% comfortable with. And then as the process goes on, if we don't put an end to it at the outset because of issues, we will then, when we get to the ministerial stage, again consult with Foreign Affairs and consult with some of the reports that Mr. McSorley was referring to, human rights reports, to get a sense of what the circumstances would be for this person in the foreign country. And Foreign Affairs is very much involved in that discussion. And then if the person is extradited, and sometimes they're extradited conditionally pursuant to assurances, then, as I mentioned earlier, Foreign Affairs is responsible for basically dealing with those assurances. So if we ask for oversight over the trial, it would be somebody who would be in our mission in the country that would attend the trial to observe, to make sure the consular affairs are handled by Foreign Affairs, so Canadian citizens have the right to consular services while they're serving a sentence in another country. And et cetera. So once they're moved to the other country, then it's Foreign Affairs who has the lead.
Familiar with the Halifax proposals for law reform that was done at the end of 2021?
Yes.
And can you comment on those? Are these from your perspective? Are there any in there that you believe we should be adopting? Can you give us any kind of, help us in this committee to try and see how can we make our laws better in this country?
Okay. Well, first of all, it wouldn't be appropriate for me to comment directly on the Halifax proposal. I have reviewed it, and I'm familiar with some of the things that they're proposing. And what I would say is it's one perspective. Not saying it's not valid, but it's not the only perspective. So it's coming from a particular viewpoint, and in order to make any determinations about what would need to be done, if anything needs to be done to change our law, we'd want to be looking at a broader range of views. So we'd look to foreign partners, we'd look to prosecution services and police, as well as the viewpoint that they have put forward in this particular report. So there's a lot of different things that are raised. One thing that I note in the report that I found somewhat surprising is that there's an emphasis on the need for us to put things more before the courts. As I mentioned, the courts are very much involved in extradition cases, but at the same time as saying the courts should have a greater role, the report disagrees with a great many decisions out of the Supreme Court of Canada and suggests that we should legislate differently than what the Supreme Court has said. So that's a surprising aspect of the report from my perspective. There's also, let's see, there's a number of things that I've mentioned are not consistent with what I understand to be the principles of extradition. The presumption of good faith. Presumption of good faith is a fundamental presumption. We refer to it as comity. It's a fundamental presumption of extradition. Without it, you can't have extradition. It means that you don't trust anybody else. So
I guess further to that, what happens in our country and in our system when there is a presumption on our part that what we're presented with is reliable, and then at one point you find out it's not?
So any presumption is just that. It doesn't mean that it can't be set aside. So it doesn't even necessarily need to be set aside by an argument from the other side. We could review something. Our presumption is that it's reliable, but we look at it and think, I don't quite understand that. That's problematic. We go back to the foreign state and ask them for input. So it's a very give and take kind of process. So by saying there's a presumption of reliability, that's a starting point, but it's not the end point by any means.
Thank you. Thank you, Ms. Diab, and thank you to all the witnesses. Thanks once again for coming back because of our technical difficulties last time. So you are now dismissed. We just have some committee business. I think it's committee members, if you recall, we have you may not recall, but it should have been sent to your inboxes to adopt the budget for witness claims for the present study for this current study that we're having. Does anyone have any questions in this regards? Mr. Clerk, are there all nods in favor? We're all okay with the budget? Any questions?
It seems so, Mr. Chair, as far as I can see.
Okay, so we're all good. The budget is passed, and we'll see you next week. Thank you. The meeting's now adjourned.